Joining us. It takes Zoom just a minute to add everybody into the room, so please sit tight and we'll get started in a few moments. Thank you. Thank you everyone for joining us. It takes Zoom just a few moments to add everybody into the room, so please sit tight and we will get started in just a minute. Thank you. Okay, hopefully Zoom has had time to add everybody into the Zoom room, so we'll go ahead and get started. Thank you everyone for joining us. Welcome to the latest Duke Media briefing on social justice. I'm Gregory Phillips with Duke Communications and I'll be moderating this event. The shooting of two racial justice protesters by a white teen in Kenosha, Wisconsin highlights contrasts in how police and some members of the public view activism and the private use of weapons. We have two Duke scholars with us today to discuss legal issues related to protests and bearing arms and vigilantism. I'll introduce them and get the discussion started, then we'll open it up to questions. We are recording this briefing and that recording will be sent to everyone who registered. Thanks to those reporters who already sent questions. During this discussion, those of you joining us on Zoom can submit questions via the Q&A window at any time. There will also be an opportunity to ask questions in a few minutes out loud. Thanks everyone also who is joining us on YouTube. With us today is Nicole Ligon. She is a lecturing fellow and the supervising attorney of the First Amendment Clinic at the Duke Law School, where she teaches First Amendment law. Before coming to Duke, she litigated First Amendment issues in private practice. Good morning.
Good morning.
Also joining us is Darrell Miller. He is a law professor who specializes in civil rights, constitutional law, civil procedure, and state and local government law at Duke, where he also co-directs the Center for Firearms Law. His scholarship on the Second Amendment has been cited by the US Supreme Court. Good morning to you.
Good morning.
Okay. Right, we will get started here. Professor Miller, we'll start with you. Part of the reaction to the killings in Kenosha has focused on how a white teenager was able to leave the scene and drive home after the alleged killing of two people in public. What are some of the legal conditions that set up and created this kind of situation?
Right. Well, I mean, it's a complicated set of factors. As I recently wrote in an op-ed for the Washington Post, we as a sort of society have somehow drifted in a position where persons can cross state boundaries, sometimes heavily armed, appear on the streets, again heavily armed, and there's very little that can happen beforehand in terms of an ability to stop it, with sometimes violent and calamitous results, as we saw in Kenosha. So, you know, the facts of Kenosha are still being investigated as part of the prosecution of Kyle Rittenhouse for shooting these two protesters. But it appears that he sort of self-designated himself a community protector, drove about 20 miles to Kenosha from his home in Illinois. At some point, there was an altercation that was caught on video. He ended up using his rifle, high-powered rifle, and killed the two protesters. His attorney, from what I understand, is vowing to say that he was using legitimate self-defense. There is a potential charge because I believe he might have been underage, actually, to possess the firearm that he did while he was on the streets of Kenosha. But you know, one of the things I think that we should highlight is the fact that he was allowed to get in his car, or at least be taken back home in Illinois after the shooting, even though members of the community, as well as protesters, were saying that he had just shot someone. There's an image of him with his hands up, with the rifle sort of slung around his back, and he's walking through a crowd of police officers who are just sort of letting him go. It looked like he was surrendering, but he wasn't taken into custody. And we don't have hard evidence or hard sort of statistical data on this, but it should be noted that this is quite in contrast to absolutely innocuous events that turn out very, very badly, with the death of young Black men in America. So you might remember that Tamir Rice in Cleveland wasn't even a teenager. He was a young boy who was out on a playground playing with a toy gun. The police rode up and shot him dead. We have the scenario with Philando Castile, who was a licensed gun owner, who was by all accounts following the instructions of what a concealed carry holder is supposed to do in terms of interacting with the police and informing the police officer that he has a firearm in the car, and he was shot in front of his partner. So at least anecdotally, it seems like there are, two sort of trigger fingers. There's the trigger finger for African Americans with guns, and there's a trigger finger of whites with guns, and that's really disappointing and shocking.
Absolutely, thank you. Certainly lots to dig into there. But for a moment, I'd like to move on to you, Nicole Ligon. The protests over racial justice and ending COVID-19 closures have seen different people with different beliefs asserting their First Amendment rights protests in different ways and for different reasons, and of course with varying responses from authorities and the public. But what authority do governments have to regulate gatherings and protests given the First Amendment?
Yeah, that's a great question. The government has the authority to make and enforce rules for the public health, safety, welfare, such as the shutdown orders from earlier this year. And at the same time, the First Amendment protects people's rights to free speech and to peacefully assemble and petition the government for a redress of grievances. But very few constitutional rights are absolute. And there's this elaborate body of judicially crafted legal principles and rules that govern when the government can actually limit the First Amendment freedoms and when it can't. But as a general rule, the government's able to regulate the time, place, and manner of speech in public forums with a content-neutral restriction, so long as the restriction is narrowly tailored to serve a significant government interest and it leaves open ample alternative channels for communication of the information. So in light of the newly developing health crisis, the decision to severely restrict gatherings in March or April, which inadvertently may have hindered the reopened protesters, was an exercise of the government's authority to implement such a time, place, and manner restriction in the interest of public health. And during the same time, oh no, did I just turn yellow? I'm so sorry about that. Let me see if I could fix that. Okay, there we go. So as I was saying, during that same time, the restriction in theory applied equally to protesters of any given viewpoint. So I guess moving ahead, once those stay-at-home orders were lifted and states began to actually reopen, restrictions on protests and gatherings, specifically outdoors, were likewise loosened. So this latter timing coincidentally happened to correspond more so with the Black Lives Matter protests. But I don't believe that the orders were lifted to allow Black Lives Matter protests or one viewpoint to be heard and not the other, because that would be really constitutionally problematic. Nor were the orders imposed in the first place to prevent certain speech. So in the same sense, if we're saying that Black Lives Matter protests are allowed to proceed at this time, then we're going to have to operate under different rules than we had back in March, which means that different types of protesters with differing viewpoints, so protesters who are with the Reopen movement or Back the Blue, are also going to be permitted to protest. So in other words, whether a government regulation is a constitutional and reasonable time, place, manner restriction is in part dependent on that regulation being applied in a viewpoint neutral way. And the government's going to have the right to impose these viewpoint neutral time, place, manner restrictions, as long as they're being enforced, again, in this viewpoint neutral, content neutral way.
Sure, absolutely. That makes sense. Thank you, panelists, both for those opening answers. And Nicole, you said very few constitutional rights are absolute. Professor Miller, I'd like to come back to you on that because, you know, there's obviously been an ongoing debate in this country for many, many years over the Second Amendment and the limits to it or the extent of it. And there seems to be so much disagreement, in the courts and among people over what you should or shouldn't be able to do with the Second Amendment, especially as it pertains to now we have protests, very different kinds of protests going on. Do you think the Second Amendment at this point is even useful in how we attempt to wade through protests and who should or shouldn't have a gun, when or when not, and when they can use it or can they not? Does it actually help us, given all the kind of quagmire that it's in?
Well, I think I'd push back a little bit on the framing of the question, because it is a constitutional right. It's in the Constitution. The case of District of Columbia versus Heller said that it is it's an individual constitutional right that has some power. Not every kind of regulation that the state would want to put in is going to comply with the strictures of the Second Amendment. So I think the problem isn't so much as a question about is it useful or is it helpful, because it's the law. I think a better set of questions, if I can sort of modify my answer to answer the question that I want to answer, is that essentially we're in a position where the Second Amendment is got a lot of still unelaborated content. So the District of Columbia versus Heller decision in 2008 only really held at its core something about a right to have a firearm in the home for self-protection, and you didn't have to be a member of an organized militia to do so. But a lot of gestures in that particular opinion suggested that the right might be broader. It might include rights to carry guns, to purchase certain types of guns. That doctrine has not developed yet. And so the issue here with the Second Amendment is we're operating in an environment in which the constitutional law is still not very clear as a matter of judicial rulings. And lots of people are making claims about what the Second Amendment does or does not permit in a highly tense environment. The other thing I'll just put on the table is it's always important to remember that the Second Amendment is a floor, not a ceiling. So to the extent that the Second Amendment forbids a state from making a certain type of regulation, it doesn't say anything about whether the state, for example, can allow more guns in more places. And that becomes a policy matter. As I'm sure Nicole will say, there are trade-offs. If you have lots of people in a highly charged political environment armed, it makes the ordinary peaceful process of politics much more difficult.
Sure, absolutely. And I always welcome pushback on my questions, especially from a constitutional scholar pushing back against somebody who is not a constitutional scholar. So thank you very much for that. Nicole, I'd like to come back to you, talking about this, the issues in Wisconsin. It's been reported that the curfew orders there have been applied differentially to protesters depending on their viewpoints. Now, we don't know for sure if that's happened, but could that kind of distinction in curfew application ever be justified?
Yeah, it's really hard to comment on directly, just because without actually being there and seeing things firsthand, I can't say for sure that it's happening. But to the extent that curfew orders are being differentially enforced based on viewpoint, that is viewpoint discrimination. And the application of the regulation is not going to pass constitutional muster. That's not going to be permitted by the First Amendment. So this is actually where I think legal observers could be really helpful. Legal observers are neutral third parties. They're oftentimes law students who will observe events like protests, and they'll document things like police interactions. And sometimes they're actually exempted from curfew orders. I know they have been in the past in New York. And they're frequently not the target of arrest, but this is a really strange time for a number of reasons. And in New York City back in June, legal observers were surprisingly and unprecedentedly arrested and searched. So it's coming with a bit more risk than it has in the past, but it's generally the case that no, you're not going to be able to differentially apply a curfew order to someone based on viewpoint. We can't say that Black Lives Matter protesters can't be out past a certain time, but pro-police protesters can. That's just in total contravention of First Amendment principles.
Sure, absolutely. Thank you both for that. We'll open it up to questions now. I'll remind everybody that you can type questions directly into the Q&A window and I can ask them for you, or if you would prefer, you can raise your hand in Zoom and we can unmute you so that you can ask your question directly. And anybody joining by phone, you can hit star 9 to unmute yourself, to raise your hand in Zoom so that we can unmute you. But while we wait for those questions, Professor Miller, I'd like to come back to this idea of militia, because it's something that's been hashed over a lot when people look at the Second Amendment and what was meant by a militia and whether it applies in a modern context. And of course, this year in the protests we've seen, we've had small groups of people who arm themselves and either call themselves militia or have been referred to as private militia in the media. And what does that do? This reference to militia, I mean, does that actually give any kind of group extra weight under the Second Amendment because that word is used there? And does the Second Amendment differentiate between private militia and militia that are considered to be under the direct direction of the government?
Right. So, I mean, I think the way militia members have understood the Heller decision is that it permits private individuals to sort of form militias that are not part of the quote unquote organized militia. Militia members tend to point to language in the Heller decision that made a distinction between the organized militia that we usually think of as the National Guard and something that Justice Scalia, in the opinion, refers to as the unorganized militia, which is some unclear subset of all the people. It's one of the portions of the opinion that is not as clear as it could be, because Justice Scalia also says that certain people can be prohibited from arms, and presumably like felons and the mentally ill, and presumably those people do not count as this unorganized militia. But I think that people have sort of taken this particular language and run with it as saying that, oh, look, the Second Amendment allows me to form some kind of military body outside the ordinary channels of command, or the militia clauses elsewhere in the Constitution, or in federal law. And what I'd say about that is it's not exactly clear, because there's as much history of America trying to control, or at least channel, private military behavior as there is in this sort of vision of the Minuteman or the citizen soldier. So, for example, in a case called Illinois versus Presser in 1886, Illinois basically banned a socialist labor organization from marching armed through the streets of Chicago, and in that opinion simply said that this is not part of the Second Amendment right to keep and bear arms, is the ability to form a militia outside the National Guard and parade in the streets. And there's other sort of historical evidence that suggests that the law has always been very, very worried about loosening sort of private military force that isn't under a chain of command or doing things for public purposes. And that's as much of the story as the sort of unorganized militia language in Heller.
Sure, absolutely. Thank you. I've got some follow-ups there, but Nicole, I'd like to come back to you and this notion of legal observers, because from our vantage point here in the US, we tend to think of protests and demonstrations in other countries as needing legal observers because there's no impartiality there. And in the US, I think there's just been this feeling that we are kind of above that or didn't need that. Whereas quite clearly, the different kinds of protests that we've got and the polarization there is in this country, we can't be certain of the narratives that come out of these protests in the media. But so what I'm wondering is if legal observers have been a common feature of protests in the US, in the past, because it doesn't seem like there's been a lot of discussion of them in the media. And given the alarming mention you had earlier of them being arrested in New York, do you think that there is room here for more of a clearly defined class of legal observer, such that we can, that they're needed, especially in the protests we're having right now, because you've got protests, about reopening, protests about BLM, very different constituents in those protests. How important could legal observers be? And do you think there is a need for more knowledge of them, a more broad acceptance of them in the US than maybe there has been in the past?
Yeah, that's a great question. As you mentioned, legal observers, they're not unique to the US. So legal observers, can exist all over the world and are documenting frequently it's police interactions with protesters or police interactions with citizens. I think they serve a really important role. I think they serve a balancing and a check function. Essentially, the idea is that this isn't why they're there, but if they are there, the thought is that maybe then there will be less type of biased reactions. There will be more clean arrests in terms of, we're not going to just arbitrarily arrest people because we know that we're being watched as a police force, or we're going to maybe engage differently with the police as protesters because we know we're being observed. So they serve that important checking function, but they're really critical when it comes to lawyers too, who are representing protesters or representing individuals who are involved in these cases. And they've served this function not just now. I mean, they've served this function throughout our history. Protests are so essential to sparking change in the US. And we have so many examples of important protests that have happened right here in North Carolina, right? With the Greensboro sit-ins. That's not a great example of where they were legal observers, but protests are really important. And so legal observers help to ensure that protests are not only occurring potentially in a safer way, but also that everything is being documented and reported. So frequently you'll have organizations like the National Lawyers Guild who will train law students or train individuals to actually be legal observers. And they act as these neutral third-party observers. They're not like the press, which is also frequently, a neutral third party, but they're not there to document in the same way. They're there to actually take a notepad, write down what's happening, and whenever there is a case that might occur, if you see an arrest that you think is problematic, then you write down that information. It gets fed back to the attorneys who are actually going to be prosecuting or defending in those cases. So there's this really important role that they serve for the Commission of Justice. And so do we think that these are positions that are here to stay? Absolutely. Do I think that there are things that we should encourage people who are interested in the Commission of Justice to pursue if they feel comfortable doing so? The pandemic, I think, poses a lot of external risks that are completely aside the point, right, with regard to public health. And I don't want to encourage anyone to do something they're not comfortable doing with for that reason. But I think that legal observers are really important. And there are, as I said, states that will sometimes exempt these legal observers from curfew orders and from certain restrictions. As a legal observer, your role is not to play medic. Your role is not to get involved and play mediator between police and protester, but your role is to observe. And if you're doing that job right, then the chances that those people are going to actually be interfering with police commission, with police arrest, or with really anything with the success of a protest, it's very minimal. So sure, I think that we should definitely encourage the people to become legal observers and encourage greater protection for them. Exempt these people from curfew orders if we can, because these are really critical roles, and they're good for everyone, right? They're ensuring both sides that everything is being documented, and I think that they play a very important role.
Sure, absolutely. Thank you very much. Here's something that I would like to get both of your perspectives on, given that it touches both the First and Second Amendments. And this was a quote I found in the Iowa Law Review recently. A constitutional scholar wrote that it has been argued that exercising First Amendment rights of speech and assembly is both physically and theoretically incompatible with open carry at protest events. So I guess, there's this feeling of safety that we need if we're going to exercise our First Amendment rights, but obviously there is a feeling of terror that can come about when there are a lot of people open carrying a gathering of large numbers of people. But these are both rights that to some extent, I guess, are enshrined in the Constitution. Is there a fundamental incompatibility there, Professor Miller?
Well, I think that there is at least a challenge with trying to reconcile these two things. So, the right in the Second Amendment is a right to keep and bear arms, and so people that believe that you have a right to have guns, anywhere you happen to be, focus on the bear part. The right in the First Amendment is the right to peaceably assemble. That is, you have to assemble in a way that does not disturb the peace. And sort of the fundamental challenge, I think, is trying to square these two things, where to some, not all, but to some, the mere presence of lethal weaponry in private hands at a protest is sort of terrifies, and therefore is a potential challenge to the peace. And so I think the answer to the question isn't necessarily found just in sort of doctrine, although that's a way to begin. That is the long history, for example, of trying to prevent masses of privately armed individuals, often quarreling with each other, of meeting in the public square under English and American law. There's also what we might think of as the addition of the behavioral sciences and localism. So obviously, in some jurisdictions, a collection of hunters that meet and then go to go hunting, or a collection of armed individuals that are a part of a shooting club. Well, that's a collection of armed individuals, but that doesn't seem to be a challenge. So those are a way to reconcile that, the assembly and the Second Amendment rights in that context. But in other contexts, like in a densely populated urban area, where people are showing up with firearms, the norms and behaviors and expectations and the perceptions of what is happening are going to be totally different. And I don't think that question can be answered totally by just doctrine. It has to be answered by questions like, do you fear going to a place to register your political views if you think that there are going to be armed private individuals there? And that's the kind of empirical studies, that's the kind of sociological and psychological studies that would bring a lot of light, I think, to the question that you asked.
Sure, thank you, Nicole. Have you got anything to add to that?
I really agree with what Professor Miller just stated, and I think that there's a lot of research and data that needs to be collected and done in order to be able to answer that question. Though I do think there's a truth to it, that it's very likely, and I can't say that this is what the general population is going to feel, but I think it's very likely that there is some element of chilling that will occur if you have protesters that are going to be met with counter protesters who are bearing arms, brandishing weapons. And so I think that, the question is not so much what, these people have weapons, it's why do they have them? Is it necessary to their speech and for a counter protester to maybe be holding those weapons? And if the answer could differ depending on who's actually the counter protester there, but it's also the perception that the protesters are going to have of why are these people holding these weapons. And so I do think that there is this element of chilling that could definitely occur, but I agree completely with Professor Miller. I think that that's something that really needs to be examined and looked at, and it's going to be done on a case by case and factual basis. So it's hard to answer that question, but I think that there is definitely a plausibility that there is accuracy behind that statement.
Sure, thank you. I'd like to remind everybody that you can type questions into the Q&A window, or raise your hand in Zoom if you would like to ask a question. We do have a question, and Professor Miller, it's for you. They would like to know, what limits do these militias or self-described militias operate under when they are kind of out patrolling the streets and operating at protests?
Well, I mean, it's state by state. After the events in Charlottesville with the Unite the Right and the tragedy that happened after that, I think there's a professor named McCord, I believe is her name, at Georgetown, who put together a comprehensive report about state by state what are the restrictions on private militias. And it really depends on what state you're in. Some states have a long track record of actually forbidding this kind of activity. For example, the state of Washington in the early part of the 20th century had outlawed private organizations of armed men, in part because what had happened was that big moneyed interests were using private military to engage in labor suppression. This is the time of the period. It's called Anti-Pinkerton legislation, because the Pinkerton Detective Agency was notorious for being a tool of sort of plutocrats and putting down labor organizations. There's that kind of history. Again, it's going to be a state by state kind of analysis about what these militias are empowered to do and what they can't do. I think the bigger challenge here is that in some ways, a combination of beliefs about the Second Amendment and what it stands for, fairly generous laws about open carry and stand your ground and self-defense, and the low barriers to coordinating lots and lots of people through social media have essentially created an environment in which it's plausible to have many armed individuals show up in the public square and not really be members of a private militia, as much as a group of individuals with firearms that show up at one point. And it has the same potentially pernicious effect in terms of risk of injury, risk of confrontation, and potential chilling of speech of people that don't show up armed. So I think that's the real challenge in the 21st century.
Sure, absolutely. Thank you very much. Nicole, I'd like to come back to you. There is a case pending before the Supreme Court about whether protest organizers can be held liable for violent or illegal acts conducted by other protesters that aren't under their direction. And the Fifth Circuit has allowed a case against a BLM organizer to go ahead, in which a police officer is suing the organizer based on damage sustained when another protester threw a brick at him, not under his direction. Why are those cases important, and what could that mean for protests kind of going forward?
Yeah, so the U.S. Supreme Court is right now considering that case that you just mentioned. It's McKesson v. Doe, and they're considering granting cert, so actually hearing that case. And it concerns this question. And Darrell McKesson, who's a Black Lives Matter organizer, he organized a protest, just for some background, he organized a protest against police brutality in Baton Rouge, Louisiana in 2016. And as you said, during that protest, there was a protester who, unbeknownst to McKesson at the time, actually threw a rock at a police officer. And so despite the fact that McKesson did not perform or direct or encourage the assault, the Fifth Circuit, as you mentioned, has allowed the police officer's suit against McKesson, seeking damages for the injuries he incurred at the protest to proceed. And the action is actually based on the premise that McKesson should have foreseen the possibility of violence at the protest, and he should be held accountable for it. So I really think that in order to preserve this right to protest and assemble, that the Supreme Court really needs to intercede here, because we're attributing blame to these organizers in a way that I think is untenable. When you go back and you talk about the original George Floyd protests, I think that coverage of those peaceful protests in George Floyd's name were frequently overshadowed by discussions of destruction and looting and rioting. But the blame for violence and for illegal acts is often misattributed to organizations at the center of anti-racist activities, so like Black Lives Matter. And just going through the evidence there, looking at videos that have surfaced that show rioters who are seemingly unaffiliated with the Black Lives Matter movement, tagging buildings with BLM or engaging in looting, engaging in violence. We've also seen unprovoked use of gas canisters and weapons by the police as well. You know, all of that is really concerning, but not only have numerous organizers of the Black Lives Matter movement actually not condoned this type of violence or this type of activity, but they've actually condemned it. And so conflating peaceful protests run by these organizers with those who are opportunistically engaged in destructive illegal activities is really concerning. To deny that protests have sparked numerous important changes in our country is to really be ignorant about our nation's history. But to hold organizers accountable for the actions of anyone near the scene of an organized protest, even when those organizers did not condone or encourage that kind of behavior, is to really risk the right of protest. And that's at a time where I think that we all really need to be working together instead of chipping away at the First Amendment, right? We can't expect organizers to be able to control everybody who shows up at the protest. There have been so many examples of people infiltrating protests. And so it's really concerning. I'm glad you mentioned it. I'm really hoping that the Supreme Court does take up that case. The First Amendment Clinic at Duke actually filed an amicus brief in it. So we have an interest in this as well. And we've set forth what we think is a really important position to be heard by in the case. And so we're hopeful that the Supreme Court will consider it and consider revisiting that opinion by the Fifth Circuit.
And if I can weigh in on this particular issue, I think it's worth noting. Just how sort of racial perceptions about what is happening when you have armed protesters really sets the narrative. If Black Lives Matter, for example, was committed to the same type of armed protest against police violence that we saw in terms of armed protests to mask mandates in Michigan, I have no doubt that the narrative about what is happening would be completely different. It would be seen as dangerous, anarchic behavior on the part of Black Lives Matter against the government, as opposed to how it was tried to be portrayed in Michigan, which is assertions of constitutional rights to bear arms against an overweening and oppressive government. Whereas I feel fairly confident that if you asked, some African Americans in these communities, do you think the police are your friends, or do you think that they are the objects of an oppressive government? They would say the latter. I can demonstrate from history the different reaction to this. So in 1967, no less than Ronald Reagan, then the governor of California, prohibited the public bearing of arms. And what precipitated this act, the Mulford Act that he signed, was the fact that the Black Panther Party for Self-Defense, which was its original name, had begun armed patrols of Oakland to watch police officers and their interactions with the Black community there. And when they were potentially disarmed, what happened was that they staged an armed march on Sacramento. And as a result, there was nationwide attention, and Ronald Reagan signed this act saying that he saw no reason why people should be carrying arms publicly in the state of California. So it's almost impossible not to think about the issue about public arms without thinking about the racial denomination of this type of behavior, depending on what group we're talking about.
I'm so glad you brought that up, because obviously that's a huge question. And mostly today we've been talking about specific legal remedies and what the law says. And of course, the law is not supposed to differentiate between people, certainly not based on the color of their skin. But we also know, as you just brought up, that clearly police perceptions of protests and the public's perception of protests varies greatly based on who's armed and what color those people are. And of course, we also know that the Constitution from the beginning, while claiming to be holding all men to be created equal, clearly did not do that. And some might say still does not do that. So that leads to a question, which I realize is too huge to get your arms around in 200 years, let alone a few minutes. But is there a way, do you think, that the law could or even should somehow acknowledge our racial perceptions, our racial differences in how we approach these kinds of situations. Because as we know from your mention of the Mulford Act, the perceptions of gun control and the need for it vary greatly based on who's holding the guns. Can the law do anything to help us navigate those differences in racial perception?
Well, I mean, like I said, you're asking me to take on 200 years of history, or even longer, both
Yeah, if you don't mind.
about constitutional law and race. So, look, the principle here is that rules are supposed to be applied equally, and that the race of the person asserting the right is of no consequence either way. And so the to the extent that we might think, for example, that it would be dangerous to have armed Black Lives Matter members, facing off against armed private militias there to act as sort of deputies for the official police department. To the extent we don't care why the people are showing up with private arms in the public square to protest. You might just want to say it needs to be equal, right? Either everybody gets an equal right to do it, or nobody has an equal right to do it, because it's not a right to anybody. That seems to be just basic principles of applying what the equal protection of the law is supposed to be. I think the other issue, and this always gets into the granular nature of policing, is there's a hell of a lot of discretion that's reposed in, police departments and individual police officers. It's known that the perception of Black people with guns and white people with guns tends to be different, and so there needs to be training to avoid that as a practical matter. So that's the way I would try to solve it in the next day or two after 200 years.
Sure, thank you very much. And I guess a slightly similar question for you, Nicole, in that we've seen obviously crackdowns on First Amendment rights being very different based on who's protesting and what they're protesting about. Do you see any way that the law can help navigate that, or is it simply the case that, okay, if the law is not being evenly applied, we need better training so that the law is evenly applied?
Yeah, I really think it's mostly the latter. I know the National Press Photographers Association has done some police trainings about this and trying to train people specifically around reactions to the media. And I think that we could do similar things around reactions to protesters. Realistically, I think that it's going to be really hard to break that cycle. I think that there are a lot of implicit biases that are completely unfounded, that are preventing this equal type of commission of justice and this complete overreaction towards some individuals and not others. That also being said, I think that it's not just in this instance, it's not just even about race. It feels more personal potentially to police officers, because we're talking about people who are screaming back the blue versus people who are protesting police brutality. And so I think that there is a concern about viewpoint discrimination in that regard too. And we need to do a better job of training police officers, and potentially, this is a whole other discussion that I don't think we should necessarily get into, but qualified immunity is something that really does protect police officers from acting potentially discriminatorily in these instances. And I think that there's not a lot of police accountability with regard to this differential enforcement of the law when there really should be more of it.
Sure, absolutely. Thank you. And if anybody is interested in this concept of qualified immunity, we had a briefing on that back in April that you can find on the YouTube Duke Media Briefings page. So please do check that out. We're going to wrap up here shortly. I'll give one last call for questions. You can type a question into the Q&A window or raise your hand in Zoom and we can unmute you. Or if you're on a phone, you can hit *9 to unmute yourself. Or to request that we unmute you, so that raise your hand so that we can unmute you. That's what I was trying to say. Professor Miller, I'd like to come back. You mentioned earlier your recent op-ed in the Washington Post And you wrap that up by saying that the tolerance for heavily armed, self-appointed peacekeepers in our public square is not required by the Second Amendment and is wildly imprudent as a matter of social policy. In this extremely volatile time in American history, and despite all the legitimate concerns about police violence, it is better to have law enforcement performed by professionals accountable to the people than private groups accountable to no one. What do you think is the best thing that can be done to prevent unaccountable private groups from exercising what they believe are their rights to go wandering around with assault-style weapons and doing what they're doing? What do you think can or should be done to get law enforcement back where it needs to be?
Right. Well, I mean, it's a really, really hard question, because in some ways the sort of genie's out of the bottle. One thing is that, and what worries me is we have to sort of understand that the tolerance or the norm of having your political position in the public square supported by arms is just not something that we usually think of in a well-ordered society. This is something that you see in other countries that have fragile democracies, not in a stable democracy like ours. And so part of the issue, I think, is just to have a different sort of perception about what's going on when armed individuals show up in the public square. In terms of the policing aspect, like I said, there is a state-by-state set of rules about when people can show up publicly to use arms or to enforce the law. I don't think it's helpful, where, notwithstanding all what Professor Ligon said about sort of back the blue and, police officers maybe being sympathetic to armed private citizens showing up in support of them. I do think that police departments and cities have to be careful when they promote or encourage this kind of behavior, in the same way that I think that if Black Lives Matter started to say, we're going to have armed patrols watching the police, that equally, I think, is something that doesn't need to be encouraged by these parties. Whether there's some kind of, more robust rules about public carry or limitations on the ability to use force in a private capacity, those are also options. But I think the very nature of the question is one that is complicated, and it's going to, we've ended up in this position by fits and starts, and it's going to take a gradual process to climb back from where we are.
Sure, absolutely. That's 100% true. And I do appreciate both of you attempting to get your arms around these huge questions that are so existential to this country and its history. We're about to wrap it up. I've got one more question, same question for each of you. And it might, again, seem like a big one, but I'm hoping to kind of make it small. And that's, Professor Miller, as you just said, it's going to take a long time to untangle the various threads of these things. What I'd like to know from each of you, from your various perspectives, is one thing that you'd like to see happen now as a kind of first step towards improving a situation, whether it pertains to the Second Amendment and gun rights, or whether it pertains to the ability to maintain peaceful protests. But I'm just interested in one thing that you'd like to see. And it could be, feel free to restate a point, but it certainly could be something from a governmental perspective, something from a public perspective, or a police perspective. Just interested to see, because generally you guys will have at least one thing that you'd like to see happen right now. So Nicole, if we can come to you, what's one thing that you think could improve the situation that could be a great first step now?
Wow, that's a really tough question, trying to find one thing. I think that if I could find one thing, it would be just a greater appreciation for viewpoint diversity. I think that these protests, again, are obviously going to feel so incredibly personal, but I do wish that as a society, we weren't so quick to say, I know what that protest is about, and I don't support those people, and look at all, and then kind of ignoring the actual message and skipping to things like, and do you see how they're engaging in looting, and do you see how and I think we're doing a lot of blending of things that we don't like, and we're conflating them with messages that we decide just offhand we don't agree with. So it's been really disappointing, at least to me, to see how people have sometimes talked about these Black Lives Matter protests, because the coverage and it's not just coverage by the media, right? It's just people will actually go out and look at these protests, and they're conflating people who are completely unaffiliated with protests and movements with the actual protesters who are peaceably assembling and engaging in peaceful protests. So I really wish that we did a better job, I think, of understanding where, why are these viewpoints necessary to be heard? Where are people coming from? And being able to actually differentiate who is actually involved in a movement and who is maybe opportunistically engaging in something that is completely separate from maybe the Black Lives Matter protest, or this goes not just to Black Lives Matter protests, it can go to Reopen, and trying to understand where people who are Reopen protesters, where are they coming from? How have they been affected by the pandemic? So doing a better job as a society of listening to viewpoints and being not so quick to judge. And that is not even a matter of enforcement, though. Again, we could talk about how police can really play a role in that too, and do a better job of not potentially engaging in viewpoint discrimination when monitoring these protests, but just being a little bit more open-minded and understanding where people might be coming from, and not being so quick to judge.
Well, that's a terrific answer. Certainly you've asked for the world there, but my goodness, a little bit of empathy on this planet would go a very long way. So thank you for that. Professor Miller.
Yeah, I think my remarks are very similar to Nicole's, which is that what I would love to see is us to sort of recapture that feature of our political and protest past, which was the civil rights era of the 1960s. Martin Luther King Jr. And the Student Nonviolent Coordinating Committee in its early years recognized that violence in the public square, or threats of violence, has the ability, or has the damaging feature of undermining the message that you're trying to send. If you're trying to send a message that police brutality is unacceptable, it undermines your message to engage in violence or threats of violence. If you are concerned that the Reopen project is not happening fast enough, it feels like it undermines your moral position to not engage with others as equal citizens, but to threaten violence in order to persuade others about your political position. And so recapturing a little bit about what the sort of nonviolent spirit, nonviolent tradition in American political dynamism is, I think would go a long way.
Absolutely. Thank you. And thank you both very much for that. A little bit of peace and empathy would indeed go a long way. This has been a great discussion. We will call it there. Thank you to everyone for joining us. Thanks to our panelists, Nicole Ligon and Darrell Miller, for sharing your perspectives. Next week's briefing will return to the pandemic for a discussion on COVID-19 testing issues and vaccine development. If you'd like to attend that event, please email dukenews@duke.edu. In the meantime, please stay safe and well. Thanks for joining us, and make it a great day.
Thank you.
Thank you.